Good evening, everyone, from Caucus in the College and the Probe, to all our viewers and readers. A very warm welcome to another iteration of the Probe interviews. With us today, we have a man who needs no introduction, one of the most prominent legal names to have ever graced the country, Senior Advocate Vijay Hansaria, a long-standing Supreme Court senior advocate who has fought in more landmark cases than I could name. And it is a great honor for us to be hosting him today. And uh, a bit about us, sir. We're Caucus Discussion Forum of Hindu College, University of Delhi. We are a 16-year-old non-partisan think tank who opine on a plethora of issues. And the Probe is a student-run monthly non-profit magazine started by members of Caucus back in 2020. Since then, we have had the honor of hosting various luminaries, and it is a great thing that we can add you to that list as well. Without further ado, we'll begin with the questions. So, you have been at the forefront of the legal domain for a long time now, being a part of more landmark cases than we can even mention. I would like to begin first by asking your observations on how the Indian legal fraternity has evolved since you started practicing, and what major challenges you think it has succeeded and not succeeded in overcoming.
Okay. First of all, I must tell you, I'm happy to be among students. So I traveled back 45 years when I was a student, when I'm in midst of students. So that's a very good thing for me. I look for opportunities and I love to be there with you physically sometime, right? Okay. Now, you asked me the question as to how the things have evolved since 1980 when I joined, and we are in 2024. So 44 years of my journey in the Supreme Court. So let me tell you honestly and first that in 1980, when I joined the profession, only the average students or below average students like me used to join, and not bright students whom I can see on the screen. And that's a fact of the matter. And it is a fact of the matter, even the CGI, in one of the lectures he said, and you could Google it, you will get it. When he passed law, he met someone and said that, what do you do? He said, I done LLB and I am lawyer. But then what do you do? I repeated. Then he understood, no. What do you do for your living? So that was the concept which was there. But today, I'm happy that bright students like I see on the screen are there, and it's a matter of first choice among the meritorious students to join the profession. Much in demand. There are huge competition to get an admission in a premier institutions like Hindu or many other premier institutions. That's the first change I find in the legal fraternity sort of thing. Second change is the use of technology. In our time, we had manual typewriters. Then slowly we had computerized dot metric printers. We used to type on physical papers and then make copies. Then photostat came. Then technology came. And of course, with the invent of internet, SCC online, Manupatra, things have drastically changed. Our resources have become too wide. Earlier, we had few books, whatever books you had in the library or even the court library, bar library, they were old books. It's difficult to get updated version. You don't have money to buy. So it was very, very difficult. Now, if we have one software and good many bar association or college libraries nowadays have all these softwares available, everything is at your click, which you cannot think of in 1980s or 1990s. That's the second change. And the third is, again, here, the COVID had sent us, has made us learn so many things. Pre-COVID period, even during we had internet age, we could never have thought that we will have webinar or we will have, what do you call it, e-courts where we can adjust the code sitting here. It was impossible to think in that line. It was never happening that way. So this is another thing which has happened. And broadly, I'll say these are the things. And you are succeeded. The question has two other things as to where it is succeeded and where it has not succeeded. I think where it has succeeded is the public faith with few aberrations here and there, which can be seen, because my saying is no good public faith was there, is there, and I hope it will be there with some aberrations here and there. We'll go to the details later on. But broadly speaking, I personally think it has remained, because even now we talk of pendency of cases, huge pendency of cases, but we do not talk how many new cases comes in. Most about 2 crore people approach the court, which shows you have faith in the system. Otherwise, you will not approach the courts. Where we have not succeeded is, again, according to me, is the delay in disposal, which is a which was a major challenge and has remained a major challenge, or it has grown perhaps. The pendency in our time in 80s, 90s were in the range of 2 crores. Now it has reached 4.5 crores or so. This is a major challenge which we have not succeeded in over a period of time. And that will be perhaps the initial reaction to your question.
Thank you, sir. And very rightfully said, a law student myself, we often revisit SEC online almost every day.
Yes, yes.
So, very rightfully said. Coming to our second question, on the matter of the Apex Court, there has been ample commentary that it is the strongest court in the world and is also the vanguard of Indian citizens. Yet, over the past few years, there has been a concerning trend of the court to lean more towards favoring the executive's decisions. And it has been observed in numerous cases, like in the Article 370 and in challenge to the 103rd Amendment Act. What are your opinions on this trend, and what are your thoughts on the proposition that the Supreme Court is now de facto of the executive court?
Okay, you said it is the strongest court in the world. Yeah, it is one of the strongest courts, but there are other strong courts also. Our neighboring court, Pakistan, has done tremendous work when Imran Khan and things were there. Saturday midnight and 4 hours to vote, and the politicians did not. I have read Indian Judiciary where it just struck down sedition law. I have read Sri Lankan judgment where there was a financial turmoil or economic difficulties. It has intervened at that stage. So we must read, and as a student, you must also read some leading cases globally, especially from the Commonwealth countries or from any country, because normally we cite British cases or American cases. I mean, stop there. Please don't stop it. We had very, very illuminating judgment. In fact, I was doing a research recently in one of the cases, and I find Kenyan High Court, Supreme Court judgment was extraordinary, extraordinary. So with that, again, you said it has become executive court, but I don't think that is a right thing to think about. See, you named 2 cases. One is 370, one is 103rd Amendment. It is EWS reservation. Both were upheld. Now, let me tell you some of the cases where the Supreme Court has. Now, first, it is wrong perception that if the court decides in favor of the government, it is executive courts, and it is a free or it is a fair decision only if it is against the government. See, we have 3 wings of the state: executive, legislature, and judiciary. Both has to function within the parameters of the constitution. Each cannot be supreme, though the Supreme Court is called supreme. Each cannot be supreme. Parliament say we are supreme. Of course, they are elected representatives. And if you see the debates of 1950 or 51, the Parliament has said that who are these persons sitting in an air-conditioned room and deciding what the country should do? We are the representing people. But then all has to function within the constitutional limitations. Having said that, let me give you a few examples where Supreme Court has decided against the government. One is the most talked about case is the electoral bond case. I was a part of it. It was a huge challenge for us. And even, let me tell you, when the judgment was being pronounced, I was there in the court. We never thought that the court will do the way that it has done. So that is a very big judgment from the people's right, from the opacity it has come out. It was hugely defended by the government. It was a battery of lawyers on that side. We were lesser number, and the other side was a more in number. Thereafter, there was a difficulty in getting the details before election because the government thought if it comes, it will have the election. But Supreme Court came down heavily, and it said, no, nothing doing. You have to declare it within the time we have given you, and it was declared. So that is one of the judgment. Second, let me tell you, is the judgment regarding Sita Soren judgment. That was again a part of it. That was the judgment with cash for vote. There was a 1992 Nashima Rao judgment where we say that bribe takers, if they vote, accept crores of rupees, vote in the parliament, nothing can be done. All that you have to say, yes, it is a nexus with my performance of duty, my voting in the house, so you can't touch me. That judgment has been overruled recently. I was a part of it, where we say that you take vote. This is no democracy. This is no privilege that you take vote and take money and vote. What is this democratic system? Supreme Court set aside that and said, no, legislators, parliamentarians, if it is found, again, it has to be on facts, it has to be found that if you have taken cash or money or there was other consideration for vote, you have committed an offense of Prevention of Corruption Act, you are liable to be prosecuted. That is second. Let me tell you third case, NJSC. So, because the appointment of judges, I'm sure you will be asking me questions on collegium or appointment of judges. I'm sure about that because any discussion can't end without that, and it should have. But NJSC, Supreme Court, all political parties unanimously wanted NJSC, National Judicial Appointment Commission, where the judges would have a say, but not the majority say, not the dominant say. Supreme Court struck it down. There was a huge uproar in the government, and even all the political parties joined there. All of them wanted, yes, judiciary should not have primacy. That is the third judgment. Recently, yes, another judgment was regarding Bilkis Bano. Godhra case, 14 persons were murdered because of communal riots. 12 persons were given life imprisonment. Gujarat government gave them remission and took it out. People celebrated. It's unfortunate. But Supreme Court came down heavily. They have to go back to the jail. And then it is another case where the Supreme Court, people's faith in the judicial system has remained. And regarding the two cases which I say 370, what is 370? It's a special privilege to a particular state. If you read 371, 371A to J perhaps, which are a special privilege or special provisions with regard to various other states, Andhra, Mizoram, northeastern states, even Gujarat, even Maharashtra. Do you say that no, that cannot be changed? We have a law that any part of the constitution can be amended except the basic structure, as per Keshwanand Bharti. So if it is not a basic structure, of course, there were arguments both sides. But then you cannot say that it becomes an executive court because it is Appel 370. Similarly, 103rd, it is EWS reservation. EWS reservation, again, there was a minority view, there was a majority view. 3 judges said it is constitutionally valid, 2 judges said it is constitutionally not valid. So if the 2 judges were right, see, again, one can have issue why reservation at all. But if you have a reservation for a particular on a social basis, on a caste basis, poorer people also deserve an extra push to come to the mainstream. That is the reason what it is given. So I don't think because of 2 reasons we can say it's an executive court it has become. Okay, we'll go ahead further. Otherwise, I can go on, speak on one subject on and on. It doesn't matter. But then I'm sure with 3 of you are there, you will be. We want to go it on a further larger issues debates.
Thank you so much for that. So that was a very thoroughly enlightening answer and very much important because I have seen that law starts to polarize in terms of opinions as well, that people start pushing a certain set of opinions. So it was nice to hear that too.
Because see, again, the perception is people talk to me not only in this interview, others say that in the Supreme Court, that's a government ke saath hi hai. It's not correct. Supreme Court also is bound by law. Supreme Court cannot say, no, we will struck down these, that, etc., etc. Let me tell you, there are 106 amendments of the Supreme Court. How many has been struck down from 1951? I think 3 or 4. NJSC is one, Minerva Mills is another, then recently cooperative thing, and some reservations issue they have struck it down, but it has been restored, and the Supreme Court has upheld it. Ultimately, again, you have to respect the amending power of the Parliament to amend the Constitution.
So building on the same, you have mentioned judicial tendencies and how the judiciary is also bound by the law. So, two common narratives which come into the foray always are judicial activism and judicial evasion. Now, two examples which have been cited recently for the same are, one is Article 370 and the court's non-adjudication of the downgrade of Ladakh to a union territory, and second is in regard the marriage equality case, where we recently had a chance to speak to Advocate Dr. Gautam Bhatia, and he said that this was a case where the court pushed an issue from listing all the way to judgment within 10 months, which is a very rare instance. So I would like to ask you, according to you, what level of self-regulation do you think judges should practice on key constitutional matters?
See, judges are bound by oath. If you read the oath, I think that answers everything. You have to decide as per law without fear or favor, to the best of your ability and conscience. Don't involve your personal views. You have to go by the law. Of course, when you interpret the law, especially in social issues and same-sex marriage, etc., one definitely goes into the personal beliefs it is there. But ultimately, you have to interpret the law, how the country thinks, what is and should be the law. Talk within the parameters of law. Again, the same-sex thing was also 2 judges were on one side, 3 judges were on the other side. It could have been the other way around also. We had this 3 years to on very cutting to fine, right from Keshwan and Bharti, 13 judges, 7 were on one side, 6 were on the side. It doesn't mean that the 6 were wrong or 7 were right. Because there were 7, they are right. Because there were 6, they are right. It has been happening that yes, previous minority judgments are become the law of tomorrow. But judicial system has to evolve in the way. And this activism or passivism or evasion are what we call it in public or in social media. These are the expressions which has come. There's nothing like activism. I don't say that, yes, all right, you entertain in each and every issue, because that everything goes on PIL. Again, I'm sure that PIL will be discussing it. But everything goes in PIL. Everything cannot be done by the Supreme Court. अब सड़क भी खत्म हुआ है तो सुप्रीम कोर्ट, एंड नाला में पानी भी नहीं आ रहा, नल में भी नहीं आ रहा, and then see, again, everybody has a limitation. I always believe that Supreme courts are meant to disputes settlement mechanism. 2 people has dispute, 2 parties have dispute, state and individual. 2 individuals have dispute, 2 organizations have dispute, 2 corporate house. That is their primary thing. PIL concept has different, of course, public interest, but then you would be agreeing that out of 100 public interest petition, maybe 5 would be worth considering. So merely because 95 are not entertained, that doesn't mean they are evasive or anything like that. Or if 95 are entertained, that becomes activism. Activism is not good again. Ultimately, public interest petitions are decided on the perception of the individual judges again, apart from the constitutional aspects, whether there should be lights should be there, and you name everything, and then but there's a PIL on that. So activism does not depend that you entertain petitions in each and everything. Recently, we had debates whether chief minister inside jail should be there or not. Let the MLAs to take a call. The law permits them to contest from jail. We had 2 MPs from jail who contested from jail. Today also we are in jail. We have in the latest Lok Sabha elections, if the law permits. The courts have said in many cases that charge sheet should not be there. But if the law permits, till the time law permits, one has to bound by it. The courts are as much bound by it. Not that courts are above law. As I said, that all the beings has to function within the law. Having said that, it was how much priority is to be given. Of course, that depends on the Chief Justice. How much priority is to be given. We have to believe in some institutions. Some cases are decided within, say, months. Some cases are not decided within years and decades, even generations. We have all family dispute cases which are pending for not only years and decades, but generation to generation. Because many times within the family dispute, people come to me and say, please don't go. You will be giving your heirs litigation in as a gift. Don't do that. Forget about it. But then that's unfortunate again. But that's the fact of the matter. Of course, all cases must have priority. Where public interest is involved, it must have priority. 370 ought to have been decided much, much earlier. Whatever way it was decided. No doubt about it. Where individual liberties are concerned, it ought to be decided much earlier. We are seeing Kejriwal today also, we have seen his bails are, of course, decided much faster. There are many other cases where bail petitions are remain pending. We are not on the results of it, but expediting thing. But ultimately, at the end of the day, you cannot put everything in order. That all right. The first come first serve, or that principle may not apply to all cases, and somebody has to decide. Chief Justice has decided. One can debate at all right. Same-sex case could have waited. 370 should have precedence. I fully agree with you. But then my agreeing and the Chief Justice agreeing there, you have to leave it to the court. You have to leave it to the court, mainly because the Chief Justice heard it earlier. And you see the Chief Justice's view is the minority view in that. It's not the majority view. So one could have said, all right, he made a constitution of such judges, we will go with him. Not correct to say that. I always believe that institutions, be Election Commission of India, be the Parliament, we have to trust institutions. There are aberrations sometimes here and there, but then that's why there are checks and balances between the various institutions. That's how we go. Okay. Yeah.
Yes, sir. Thank you for that erudite answer that the Supreme Court is meant to be a court of managing disputes and that they are also bound by law and checks and balances must exist.
Yeah.
Coming back to the issue of whether or not deciding cases in favor of executive would make Supreme Court an executive court, there's only one rational reason that a judge would be partisan towards the executive, that is the seeking of post-retirement jobs. Recently, multiple reports have pointed out that many judges often seek post-retirement opportunities, which has attracted the allegations of bias in certain cases and thus the term executive court. What are your opinions on the same? And do you think that there's an alternative system to counteract this issue?
See again, I have been telling, what is the power of the Supreme Court? They don't have purse, they don't have sword, we have only public faith. You have to retain that public faith. And how do you retain public faith? Independence of judges. That is where the perception comes in. Where the people perceive that you are not independent, nothing remains. If you're not independent, why do you go to courts? Why do 2 crore people go to court? And if you're not independent, there the perception has to remain. Otherwise, people will come on the streets and then settle their disputes. It's very important. And one of the things which I personally believe is regarding post-retirement appointments which has been given, because we all know that they will retire at the age of 60 district judges, High Court judges at 62, Supreme Court judges 65. Government servants retired at 60. Ministers, of course, there is no retirement age. But if there is a retirement age, and if the executive has to say, and executive is one of the most important litigant before you, definitely there would be, actually or not, there is perception that you are not independent. You have not decided cases independently. If you are granted a post, which I would categorize in 2 different categories. One is political, another is, you can, statutory. In both cases, according to me, there should be a buffer period. So that if there is a buffer period of 2 years is there, then I don't think 2 years, after 2 years, what is going to happen? That will enhance the faith. If today you retire and tomorrow you join the parliament or you become the governor, definitely people have apprehension that you have not been fair. And that is the only thing which they must retain. And it is only thing which the judges can manage, is to have public confidence. And they must, even arbitration, I personally feel that otherwise people say you have decided in favor of some big corporate houses and thereafter you have been given arbitration by some organizations or linked to that, etc., etc. There should be a buffer period of at least 2 years post-retirement before. And then there is an argument against that there are so many statutory authorities like Human Rights Commission, like consumer courts, like electricity tribunal. There are so many tribunals which are to be headed by Supreme Court, former Supreme Court judges. How do you do it? Because the former Supreme Court judges have to be appointed, but then have it 2 years buffer period. What is the difficulty? You know you are retiring, and Supreme Court judges are retiring at 65, fairly advanced. I will not call it because I myself has crossed 65. But I'm saying that all the government servants have 60, retire at 65, 60. District judges retire at 60. They settle down. You know, you plan your retirement life accordingly when you are in service. you save accordingly. Thereafter, to maintain the public image, it is very necessary for me to have not to get any appointment, be it much less political, which actually there are not, I'm not going into that. It may not be actually favoring, but at least there is a perception and rightful perception that yes, there is a quid pro quo thing. You decide in my favor, I'll give you this. There has been many instances. I don't want to name any one of them in this debate, but then you all know what your question indicates, what is there or what is not there. Definitely there should be there, and that is where one thing we need self-regulation. And if the judges have self-regulation, otherwise someday some law would be made. I hope some law is made that all right, you cannot have at least for 2 years any post-retirement engagements, and that will go a long way in maintaining the public confidence in the system. Yeah, we can go further.
Yes, sir. Thank you for that answer.
Yeah.
That a cooling off period is
I
very
hope
much
if
necessary.
you don't agree with any of my answer, you can of course ask me, and then I'll correct myself. I have no difficulty on that.
Yes, of course.
Yeah.
But having said that, I do agree that a cooling off period is necessary for the judges in order to maintain the legitimacy
Yes.
in front of the public.
Yes.
Okay, sir, as you had rightly pointed out in the beginning, that in 2015, almost all the parties were unanimous in the passing of 99th Amendment, that is the collegium system, that is abolishing the collegium system and establishing of a NJAC. And I remember that the only member voting against it was Ram Jethmalani. And coming to the issue of collegium, that the opacity of collegium's decision making has been a focal point of the debate since the system began in 1993. In regards to that, how do you see the collegium's decision to not disclose the reasoning behind their decisions, and what are your thoughts on the defense that the opacity safeguards the independence of judiciary?
See, first thing, whether there is a collegium system or there should be some other system, let me tell you, we had pre-92, pre-82 or 92, that first judge's case said that president has the primacy. Then we had the second judge's case, 92, that we had the collegium system was introduced. Somebody has to take a decision, whether the president means the executive or judges who decide among themselves. But there has to be again checks and balances. You cannot say merely because the government is there or government representatives are there, they become biased. So there has to be a balance between the two. It should neither be exclusively judges, it should neither be exclusively government, and public should also be involved. It's not that we are 140 crore people. Can we not find out one person whom people by and large will have confidence? In fact, I have written some article in SCC online. You can find out. Some balancing is required. NJSC did not create that balance. It inducted law minister, 2 Supreme Court judges, 2 members of the civil society or eminent jurists. So they just did not have the majority. The 2 eminent jurists, so-called, that you can veto any amendment. My personal perception is that a balance can be there where the Supreme Court judiciary would have primacy because they know who are the judges, who are they. Government should also be involved. We cannot say merely because the government is involved, because the government is elected by the people. They reflect the will of the people today. Some of us may agree, may not agree, but they take decisions whether there should be nuclear war, there should be war with the foreign country or not. So you have to trust the government also. Thirdly, the civil society also. Someone says civil society, who is this fellow, and then all that. No. There is a big contribution of civil society in the running of the state. You cannot say that. A better system is required. But presently, as we say, but we cannot live exclusively with the government, according to me. And we should not have exclusively with the judiciary as well. And let me tell you, which says opacity. What do you want? Your entire life, there are certain benchmarks which should be, again, according to me, more transparent as to what should be your income. There is a benchmark and the memorandum of procedure. How many cases you should done, Nowadays, fortunately, I think the present Chief Justice introduced in the collegium resolutions which are uploaded on the Supreme Court website, you find a brief reasoning that from that state, if the Supreme Court appointment from that state, there is no representative or something of the sort. There has to be a brief reasoning. But if you go into the very many details to say that opacity to not there, these are all subjective assessment. You can't ask the Supreme Court and High Court judges to answer as in the district judiciary. You have to write examination and interview, face interviews, and then it is there. May not be the correct way for the constitutional courts. I don't think anywhere in the world with the constitutional courts appointment is done on the basis of any examination. District judiciary, yes. Even American Supreme Court is openly is either you are a Republican or you are a Democrat. It is openly a political appointment. But then you trust, people do trust. But in our system, according to me, the checks and balances, so far as, and the collegium system may be modified and should be modified according to me. There, one check would be there the moment a person asks, other than a judge is in the collegium, there is inbuilt check in the system. Just like an open hearing, it is an open hearing. There is a check. If it is a closed door hearing, there is no check. Similarly, they decide among themselves. They decide, of course, as per the best, according to me. But so far as the High Court judges' appointment is concerned, let me tell you, it comes not directly by the Supreme Court. It comes from the High Court Collegium, 3 judges of the High Court. It goes to the state government. It goes to the law ministry. There is an IB input, and thereafter Supreme Court Collegium. So the Supreme Court Collegium wants that X should be judged. It doesn't happen. It cannot happen. It has to come from the High Court Collegium. It has to have an input from the state government. If the state government says, I know cases where the state government says, no, this man has bad antecedents, and we have materials to show that, that person will not be appointed. There's an IB problem. They will not be appointed. Of course, you have to have facts, because you cannot say that IB, some inspector has said, no, I think he's not a correct person. That will not be sufficient. If there is some material, he will not be appointed. So there is a filtration which is there. And if you have too much of disclosure, I don't think that many lawyers would like to would come, because then you are affecting his right to privacy. Suppose he may be considered, he may or may not be appointed. So if you upload everything in public domain, the problem is, I would not go. Many of you would not go. Why? I have a personal life. I have a right to privacy now recognized as a fundamental right by the Supreme Court, rightly so. Your right to privacy has to be weighed with a public right. The public cannot, and there are all subjective assessment. They're not based on any examination, and nowhere in the world is constitutional courts judges are appointed on the basis of an examination. So the checks and balances is the best way to do it, and that's how I think that it is there.
Indeed, sir. And I think that's a very vital observation when we talk about subjectivity and maintaining the privacy, and also maintaining a fine balance between both the aspects, especially when we're talking about certain cases like this. It's a very vital observation, and thank you for bringing that up. But diving into the depth of collusion now, since India is a very diverse country and representation matters. So, when we talk about representation of communities through judges within the judiciary, it has been a key point of debate in the socio-political and legal spheres. The Supreme Court Collegium was once called an old boys club, and there have been instances where there have been reports that the union has rejected the Collegium's recommendation owing to the proposed candidate's sexual or political orientation. How big of an issue do you perceive this to be? Do you think that the bench is in strict need of diversity in the modern day perspective?
See, Old Boys Club is right that in the sense that if 5 judges, they can pick up the sofa. Supreme Court is concerned, they decide it. But again, let me tell you, if to believe someone, whom do you believe? Those who are citing in social media or those who are doing some constitutional post? We have to believe in someone. I believe in institutions personally. I believe in Parliament as an institution. I believe in judiciary as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in the Supreme Court as an institution. I believe in Prime Minister as an institution. I believe in Election Commission as an institution. But of course, when any institution goes little haywire, other has to check it. And there are checks, as I told you just now, that it is not that the Supreme Court Collegium wants X and Y to be appointed. It doesn't happen. But then today, everybody has to go as per law. As you said that some candidates have not been appointed by the courts because of their sexual orientation or political inclinations, etc. That may be not be correct. The reason is this. Today, the law is, and everybody has to accept the law as it is. If NJC was there, that was the law. If NJC is not there, collegium is the law. Collegium system, the Supreme Court finally recommends. It's not that it starts the process. By the time file reaches the Supreme Court Collegium, there is a lot of filtration there. If it reaches the Supreme Court Collegium, it goes to the central government, and the Supreme Court judgment, the law is that it can return the file. And if it is returned with a reasoning and it is reiterated, then the government is bound to appoint it. That is the law, and that law must be accepted. The government may not like it because of the sexual orientation of a person. It doesn't affect the justice delivery system. Let me give you another example of Sabrimala case, where women within puberty age is not allowed to go. The Supreme Court bench had 5 judges, 1 women judge. Do you know the women judge decided against the women? 4 judges decided in favor, male judges decided in favor of the women who should go. I was a part of it again. So it's not that all right, if you have someone from a particular sexual orientation or a political, he or she will decide in a particular way. It's not necessary. If you have competence, because what are the judges supposed to do? And we have one of the finest judges who are Krishnaiyer. You know, he was an active politician before he joined. He was a communist, very hardcore communist leader, but he's one of the finest judges. We remember as a finest judge. It's not necessary. People change. And that is why at the oath, take oath and just read the oath. And somebody asked me, what are the duties of a judge? Just read the oath and that's it. Go by your oath. Keep it in front of you while deciding cases. So this is not right on the part of the government to say, we will not obey the law, and they have not obeyed the law. We'll know the names. I don't want to name it here. You all me know the names. Whom are you talking about? They are one of the, I know them personally, very fine lawyers. They are appearing in cases now. We appear in large number of cases. I appear for a wife and a female lawyer appears for husband. It doesn't mean that if I appear for a wife, I'll not be doing the case in favor of a husband or vice versa. Sabrimala case is the living example of that. So it's not necessary that judges, again, when they decide cases, they don't go by their personal views. They go by what the law they think is correct. So both the things are there. That again, the government is and the Supreme Court pushed it, but then you cannot push it beyond a point. But that is where the government is not right in not obeying the law, not appointing, and then many instances where they have appointed much later. They have not appointed some of the chief justices recommended by the Supreme Court Collegium. Again, you cannot say that will not appoint. Again, the Supreme Court cannot go to the extent and issue contempt notice against the Prime Minister, the Law Minister, and say that you have not appointed to do it. That restraint was exercised, and rightly so. But the government must also think that yes, they have done it, and I am bound by law. They must do it. So I would feel the way. Yeah.
So we duly take note of that, and we duly respect also that perspective. And thank you for enlightening us for that too. I think we all will revisit and read more about this.
Yeah.
But diving more into the authoritative aspect of the collegium system, there have been accusations that the matter of the master of the roster system has been used to selectively allocate sensitive cases. Recently, a very prominent legal name also implied that there is bench fixing going on owing to the said power. How do you believe this impacts the integrity and public perception of the judiciary and the resulting orders or verdicts?
Master of the roster, right? Who is to decide? Somebody has to decide, right? Social media won't decide which case should be listed before which bench. Litigant is not to decide which case is to be listed before which bench. Somebody has to take a call. So if anybody asks me from a public platform, I'll ask, all right, get up and tell me who should decide. You go to the court and decide, no, my case should be decided by Judge A, Judge B, Judge C, or Judge X. No. Again, as I said, that you have to believe in some institutions. There are, again, aberrations on master of the roster system also. But then Chief Justice of the High Court or Chief Justice Supreme Court, Chief Justice of India decide cases, and they broadly lay down the policies. And why this uproar? It has gone to the junior judge, right? There has been many cases selectively listed before a junior. Is the junior judge not a judge? They have equal power, brother. They have absolutely equal power with the senior judges. Merely because it has gone to a junior judge, it does not mean that you lose the faith or you accuse the master of the roster. Or it has gone to the senior judge, same judge becomes a senior judge. And we have, as I told you, that 103rd Amendment you asked me, that the senior judges, I think Chief Justice Lalit was in minority, and Justice Dinesh Maheshwari was junior to him, was the majority. So it happens, the majority judgment prevailed, and that is the law today. So merely because it has been allocated to a particular judge, not to your liking, to blame the entire system is wrong. Again, there are 5 benches which hear bail cases. No, it has to go to one of them. The results, you may presume that if it goes to one of them, it may be against. Again, judges have views. Some are, we also know as lawyers, some are pro-tenant, pro-landlord. Some are pro-revenues. Some are pro-SSCs. Some are lenient in granting bail. Some are not lenient in granting bail. But if the judge is deciding on the basis of political affiliation, that's a different thing. But again, we are all judges, are individuals like you and me. And if the judges' perception are also known, broadly speaking, we knew in 80s and 90s, there are some judges who are, if you're a tenant, landlord-tenant dispute, you have a tenant, 100% you will get it. If there's a landlord, if you go to 100%, the result would be known in advance. It doesn't mean that you give the right to the social media or to the litigant to select the judge who should hear. Then there's the end of the matter. Again, as I said, if you don't, I argued some matter, if you don't trust the Chief Justice of the High Court or the Chief Justice of India, let us close down the courts. Let the courts, let the kangaroo courts decide. That is a wrong message, which, again, I think the social media is doing a big service, a big disservice also. You raise LS biases, which hampers public faith is eroded. That again is wrong. Of course, some judges' views are there that yes, they are pro what you call jail and not bail, though the law is bail and not jail. But then that's how I heard one of the judges in a public, not the judge which you are talking about, other who is little tough. He said that no, I'm a big follower of Krishna here, who said bail and not jail is the law. He said, yes, believe it, but then I can't give bail to all cases. I have to look into the facts of the case and then decide. And people tell me that I'm a person not following that principle. I follow, I believe that. I personally respect that Judge Krishna who coined this expression that bail and not jail is the rule. But still, I can't give bail to all and every cases. See the heinous or see the law which is prevailing, under what law it is there. So that's how it is. Go ahead.
Oh, thank you, sir, for mentioning the ideology of the judge, especially in the bail cases. That judges have always had an ideology. But a common criticism being subjected onto the Supreme Court in recent times is how certain judges have built up a reputation of being ardent bail deniers, especially after how acts like PMLA and UAPA have been widely used by the executive. As someone who has practiced in the Apex Court for a very long period of time, what are your opinions on the same? Do you think that these criticisms are something which has developed recently, or do they have any historiography behind them?
I'm happy that you raised this. I personally believe where one aspect where the courts have failed us is PMLA and UAPA. See, we have laws like PMLA and UAPA. We had anti-terrorism law, which is called POTA, Prevention of Terrorist Activities Act. Then we had changed the name, came to some other before that, and we had UAPA today. These are very harsh law to deal with terrorism. But then we can't call each and everyone terrorism. Anybody who spoke 10 years back regarding give a some speech in JNU, he or she becomes a terrorist today. That is, executive sometimes does it, but there the court must rise. Put them, if you nail 5 important cases which country look forward and say that no, you have you have abused your power, let them out immediately. Make some observations against the government. It will have a big impact on the criminal law administration, and nothing is important than the liberty. If you take out the liberty, put the person who criticizes you to jail, make some law. Of course, PMLA is meant to be for economic offenses which puts hole in the country's economy. UAPA is terrorist, but you can't brand everyone a terrorist, and that the court must come heavy-handedly. Where the law is strict, then the court scrutiny has to be more strict. Courts have failed, personally believe. In some few cases where the people look forward, those persons, yes, he has been harassed, and there may be some technical part here that PMLA law does not permit. The law is valid today. UAPA law does not permit. It is valid till today. But then you decide whether it is valid or not. But send a signal to the executive, you cannot abuse your power. If you send one signal to the authorities that you cannot abuse your power, power will not be abused. Let me give you one example, not connected with bail. In Chandigarh mayor case, what that fellow returning officer did, openly he said that, all right, the law is, once the election process is begun, nobody can do it, you file election petition. The Supreme Court said, no, we will not go by those things. It is very apparent that he has manipulated the result and declared the unsuccessful candidate as elected. That is the message. Thereafter, no returning officer do it. If the Supreme Court was to decide other one, the easier way is you manipulate the result and then declare it and let him file litigation, and 5 years should pass by that time. Similarly, if you find few cases where law has been abused, and see again, we all common citizens, we all know where, or we have views. Technicalities apart. Technicality, they may be right. Supreme Court, as I said, bound by law. But in some cases, you have to send the message. And that message has not gone, unfortunately. PMLA is abused. UAPA is abused. It is used less, abused more. And where there is a possibility in actual abuse, the courts, we look forward courts. The court failed us in emergency in ADM Jabalpur. Court has failed us in recent cases, also in many recent cases where UAP and PMLA has been abused by the authorities. No doubt about it.
Thank you, sir. And I feel whenever we are talking about it's a very valid observation when we're talking about such sensitive cases like UAP and PMLA. It's very important for us to also look out from the court's perspective too, and how branding of these titles with terrorists become difficult. So we need to understand from the court's perspective. So we readily agree with that perspective. So coming down to the final 2 questions now for this interview. Uh, since this is a very interesting topic, I would again build up on the previous question that a former Supreme Court justice recently stated that a prominent case was withdrawn from the petitioner after looking at the bench composition. Keeping in mind that Article 21 of the Indian Constitution guarantees the right to personal liberty, how do you think the Supreme Court should balance this right with the need for public safety and order when deciding on bail applications? Can you provide any examples that would illustrate this ideal balance?
See, again, depending on the composition, the particular litigant thought that that bench is not going to decide in my favor. The bench is going to decide against me. He or she decided to withdraw the case, and it was represented by a very, very respectful lawyer of the Supreme Court, no doubt about it. Again, one instance where a special bench was constituted on a request immediately on the same day, which again, a common man does not get that liberty. A common man's bail application is not taken up on the same day. It takes weeks. In some states, take months together. For example, Allahabad High Court, to get a bail petition listed. Why Ram Singh's bail application is less important than a minister's bail application? It is not. But they are being heard on the same day. In some courts, I had a very serious. I say there are some VIP litigants. We have VIPs. I had very strong observations against VIPs. But then there are certain VIP litigants whose cases are listed on the same day, but the persons who are there in jail for years together, their case is not heard. Why? Raise this issue also. Why should right wrong? I recently done a case where a person was in jail for 17 years. Ultimately, court reduced it to 7 years imprisonment and let him off. I said, what about 10 years? He did not have the right to approach you. He did not have means to approach the court. We are evolving some mechanisms. Supreme Court is my suggestion. Supreme Court is looking into. That is one aspect. Of course, the bail, as I said, where Supreme Court has failed us, courts have failed us. And if you find it is abused, there are ways and means to overcome the technicalities of law, because ultimately the court is the custodian of fundamental rights. There cannot be more important fundamental right than the liberty. If you criticize the government and you are put behind the bars, you end of the matter. That is what happened in emergency. That is what is happening in many cases nowadays. People are worried that if I criticize the ruling dispensation, I will be put behind the bars. Let me not tell you only the central. In many states, that is a perception. If I criticize the government openly and vocally, in the state, I'll be troubled with the law enforcing authorities by the police. If police is abused and the courts doesn't rescue us, who else? That will be a very anarchist system. That is a very wrong signal to the society. And that is where we look upon the courts. We go to the courts. Why? When we have a fight, I remember when I was sitting with the law minister who was against the system, he said that when you have a fight, what do you say? Court mein dekh lunga. Why? Very important message. We have faith in the court. That's why we say, I don't say कि रास्ते पे देख लूंगा, गुंडे लगा दूंगा. I say court में देख लूंगा तुमको. Because we believe court as an institution. And if the court does not come to the rescue of the people or liberty of the people, and if the people is frightened before एक bench गया तो मेरा खत्म हो जाएगा, that's again is a wrong message which the courts have sent it to us. I have gone to court because I want bail. But looking at the composition, if I am certain that I will not get bail, that's a message which the court is giving it to us. The bench is giving it to us. That should not be there. The people must have faith that, yes, I can persuade the court. If court agrees with me, it will consider and grant it. And in some cases, there are ways of interpreting it. If the need of the hour is, yes, government is abusing its power, you protect the people's right. That is your first primary duty of the judiciary. I think that is how it should go.
Thank you so much, sir. That was a very striking thing to hear, especially as we sit on the 50th anniversary of the Indian emergency today. So it was very enthralling to hear you so far, especially from the other side. We have usually seen you on videos, but it's a deep honor to just have a chat with you straightforward. So just to conclude, I would like to ask you, what are your observations regarding the recent evolution of the Supreme Court, and do you think there is a way that judicial system can be made more acceptable to everyone through all these criticisms? Furthermore, what role do you foresee for lawyers, prominent lawyers like you and students like us? How can we make a difference?
See, first thing, let us see what is you have not asked me one question which I will be like to say is regarding delay of cases. We have 4.5 crore cases pending. Now, National Judicial Data Grid is real time, gives you figures. So there are roughly 4.5 crore cases pending in district courts. There are roughly, I think, 62 lakhs cases pending in high courts and roughly 80,000 cases pending in Supreme Courts. We all talk of pendency. It's 4.5 crore cases means there are two parties, there are 9 crore people. So 9 crore families are involved. And in one family, there are 4 persons and 36 crore people are looking forward to the courts are in the litigation. We all speak of that. But then we don't speak when it comes to delay and cases, how many cases they have decided, how many judges we have. There is very less talk of that. Let's give sometimes a pat on the back of the judges. We have 25,000 sanctioned strength of district judiciary. Actual working strength is roughly 20,000. So we have about 5,000 less judges than the sanctioned strength. Similarly, high courts about 1100 are sanction strength, about 800 are the working strength. And Supreme Court, fortunately, we have 34. We have all 34, 1 or 2 judges retire immediately their field, so we have actual strength. So 20,000 judges decided 2 crore cases in a year. That means 1,000 cases per judge, unparalleled in the history globally. Please say this again. Read this, write this, ask this. We decide, our judges decide 1,000, district court judges decide 1,000 cases after trial. Each trial has many times 20, 30, 40 witnesses, run, evidence running into thousands of pages. Enormous duty. They decide about 2 crore cases in a year. Now, these data are also available real time on National Judicial Data Grid. You people must see it and then put it in your discussions, etc. How much judges are working? High Court decide about 20 lakh cases in a year. 800 judges deciding 20 lakh cases, about 2,500 cases in a year, per judge per year. It's unparalleled. Supreme Court decides about 20,000 cases in a year. 34 judges, if you multiplied, it's roughly 500 cases per judge. No court in the globe, according to me, is decide that much of cases. And their perks are very less. Working conditions are bad. We have to talk about this. Their infrastructure is bad. Am I guess in one of the matter raising this issue? The funding is to be given much more. They have to be made much more attractive. I don't think any one of 3 of you on the screen would like to go on judicial service, which many advanced countries they will go, because the perks are much more, respect is much more, their living standards are much more. If you're a judge, just looking at a distance, yes, you're a judge, saab hai, theek hai. But then today it is not happening. At least in the 80s, I know judge going in a public transport bus, khada hoke ja raha hai aise, and the litigant going in a air-conditioned car. Of course, now with the judicial intervention, the conditions are better. But that is where one improvement is required about the judges' working conditions, at least the district judiciary working conditions, is very, very necessary. And you say that where we look for the legal fraternity and students like you to looking for about the legal system, I'm optimistic a person, because as I say that except few aberrations, we have retained the faith of the people in the institution. Wherever there are aberrations, we must talk. Judges must hear. They hear us in the court. They must hear these views of public also, that yes, wherever there is a leakage or in the standard of public confidence, they must plug it. It is there. It's our duty also to tell them that here you are lacking, as the lawyers are said to be the judge of judges. So, and it should be bona fide. It's just not make personal allegations here and there decided against you, so you make personal allegations. Not like that. But if you institutionally feel something to be wrong to be done, one thing again you have not asked is about the responsibility of the lawyers. I think we have also failed in the responsibility as a lawyer. We have lesser number of court hours at working days. That's a different debate. But there are a lot of strikes, lot of abstaining from courts, huge number. If Supreme Court doesn't happen, high courts, some of the high court there is a problem. District courts is a huge problem. If we have working days, the lawyer strike is there on the just drop of a hat. Lawyers abstaining from work because one of the colleagues is passed away. We have a large population of lawyers, and you find at 10 o'clock, you will find I'm compiling a data, and then you find that yes, out of 100 days, on 50 days, some lawyers have died, and so there is abstaining from work in the morning. It is decided today we are paying homage to him, and then they will be playing cards in the chamber. This is where again responsibility of the lawyers has not been fulfilled. Speedy justice is need of the hour. Use of technology is the need of the hour. Now, present Chief Justice is pushing the use of technology, and some big cases, technology has really helped us. It has helped to save papers also. It has become paperless in the Chief Justice's court, and he says wittingly sometimes, if you carry books, we'll impose cost and give it to the Bar Association. He has said that, Mr. Counsel, and so you are carrying books. In my court, books are not allowed. Even my colleagues face, is referred to some judges that they face difficulty, but they are also trying. So why don't you also try? And it has become, so you must use technology. As we say that नहीं हम तो पहले के ज़माने से है, books ही देखेंगे. Of course you must see books, but then use technology more and more. And you people must come forward to join litigation. Of course, there is another problem, and you always look for some corporates and practice and not litigation. There are problems. We will discuss it some other day on that aspect. But litigation, you can serve the people. You are getting an opportunity to serve the people. Be the healers of injustice, just like the doctors are healers of pain. Be the healers of injustice. Wherever you see injustice, say, I'm there. I think that with that note, we can conclude by saying that I'm look forward the bright people like you to join the profession and join litigation. There are problems in the beginning, but then you get a lot of satisfaction when you help a poor man and person who is not able to afford your fee and help him. And he will pray for you. He may not pay, but he prays for you. And prayer work as wonders.
Thank you so much, sir. It has been very inspiring, and it has just been wonderful to listen to, because most of the times what we hear on social media are always the negatives. So it's also a great thing to hear the positives of the same as well. And that was the objective of our student society as well. That's why we're Caucus the Discussion Forum. We're not here to just mindlessly shout at people. We're here to discuss the pros, the cons, the goods, the bad, and how we can make a difference. So it's truly been an honor to speak to you, and I speak on all three of our behalf. So thank you so much for giving us the
It's also
opportunity.
a
We couldn't
pleasure
have.
for me that you people are interested in doing this. Otherwise, people are not very interested in doing academic work. They're interested in many other things and social media. But then be a responsible citizen, and I'm happy that you are doing that duty. Thank you.